chairing the event. In all the events in this room, I'm chairing. If I'd remembered what hard work it was, I might not have agreed to do it, but it's 3 days, every event in this room, I'm here chairing it. And I will be very careful not to abuse my rights and I'll keep to time, don't worry. So I was a vice president of MySpace. For those of you, actually, there's nobody in the room old enough to remember MySpace, but technically I was based in Los Angeles, although my wife made it very clear any idea of me going to live there would inevitably involve divorce. So I didn't go and live there, but I did go there a lot. I've worked for Google. I was on Microsoft's policy board for Europe, Middle East and Africa for 6 years. And all of the time, of course, my focus was always on online child protection issues. And in the United Kingdom, I was secretary of the UK Children's Charities Coalition on Internet Safety, which was established in 1999, 1996. By the way, don't let my boyish good looks fool you. I am actually quite a lot older than I appear to be. In 96, I was a founding director of the British Internet Watch Foundation and was subsequently on the advisory board of INHOP, which is the global association of hotlines. And currently, I'm on the executive board of the Canadian Centre for Child Protection. So I've got a long history of working in this field, and I'm going to talk for roughly 20 minutes, probably a bit less, on children's rights and online safety. But there was a point that came up yesterday in one of the discussions about this question of parental responsibility and how, particularly in the United States, there's such a heavy emphasis on the role and responsibilities of parents in relation to online child protection. Now, in my opinion, we all know it doesn't work. We've tried for donkey's years, for as long as I can remember, trying to engage parents more and more with these issues, but the complexity of the issues themselves, and that's intentional, the way these things are designed, they're not meant to be so transparent because they want you to get involved in the app and they want you to get involved in the environment. They don't want to make it easy for you to control it and limit it. But within, and it's therefore a way of shifting responsibility. When companies talk about the role and responsibilities of parents, of course we all agree parents should and ought to be more involved. But the idea that they somehow are the principal burden carrier of protecting children when they're going onto these platforms that are making gigantic amounts of money for them is a fiction. But it is a very American idea. I was a lawyer originally, many years ago, and I've looked at American federal law on this subject. And let's not forget, the United States is the only country in the world never to have signed the United Nations Convention on the Rights of the Child. And that's not an accident. There is a reason for it. And the reason is that consistently, the US Supreme Court, US federal law, has essentially privileged parents' rights over children's rights. Specifically, explicitly, they say that in any consideration of the position of the child, for example, in relation to its education or things of that kind, parents have got superior rights to their children. And this has resulted in cases in the United States which could never happen in the United Kingdom, could never happen in any European country. And one of the reasons for that is that we have signed the UN Convention on the Rights of the Child, which explicitly recognizes the rights of children in ways which I will go into in a bit more detail in a moment. Whereas, for example, one of the cases that sticks vividly in my mind was of a child who had a heart condition and was also neurodivergent. And this child got very ill, and essentially the medical opinion was that the child needed an operation to try to correct this heart defect. And the parents wouldn't give consent to the child having the operation, even though it was obviously and clearly in the child's best interest for that operation to take place. What happened in the end was that the child had an arrangement with another family that used to look after it, respite care, at weekends. And some lawyers, essentially, what they did was they went to these surrogate parents who looked after the child over the weekend and got these surrogate parents to apply to the court to get an order to allow the child to have the operation. This case went all the way up to the Supreme Court in the United States, and the Supreme Court said explicitly that there was no right of the child which was superior to or different from its parents, even in respect of deciding whether or not to have a medical procedure that was obviously in the child's best interest. Now, that pattern of thinking about parents' rights and parents' obligations vis-a-vis children is deeply embedded in American jurisprudence. And it's linked partly to a very ancient, as it were, American suspicion of government in general. So anything in the United States that gives the government, and by that they mean local government, state government, city government, as well as the federal government, rights vis-a-vis families and children is deeply suspected, deeply resented, and deeply resisted. And so that's you can see why, if you're an American company developing an app and so on, this notion of parental responsibility and shifting part of the responsibility, or a major part of responsibility, onto parents in relation to their children's use of social media and technology fits very neatly with their corporate objectives, which are to essentially maximize profits by keeping children on their apps for as much as they can. I'm just going to refer to the UN Convention on the Rights of the Child and some of the, and this is let me remind you, United States aside, it's the most widely adopted international legal instrument in the history of international legal instruments. Everybody in the world, apart from United States, has signed up to it. Article 6 and Article 19 are the two key ones in this respect. Article 6, right to life, survival and development, which recognizes every child's inherent right to life and obliges states, governments, to ensure their survival and development to the maximum extent possible. And that is the foundational principle, if you like, or provision in relation to states' obligations to try to guarantee, as far as is possible, as far as they can, that children within their jurisdictions have a healthy life and grow up to maximize their potential to the best of their ability. Article 19, protection from violence, abuse, and neglect. And that includes physical and mental health, another key aspect of the international framework of law that's meant to guide the actions of governments around the world. And then there is another specific one, Article 25, the right to health, which describes the highest attainable standard of health is a right for every child. So you can see how there is a clear internationally agreed legal basis which imposes obligations on states to ensure that children, in any and every aspect of their life, get this right to protection from harm, psychological as well as physical. But the problem obviously with the emergence of the internet was that it came, as it were, from nowhere, developed very, very quickly and rapidly, beyond the capacity of most policy-making processes to keep up. And we're all now trying to have to retrofit, in a way, safeguards and safety improvements to try to address some of the things that should have been foreseen. And one other key instrument in this endeavor to try to, as it were, fix the problems that weren't anticipated when the internet first came along was General Comment 25 to the UNCRC. Professor Baroness Kidron and Professor Sonia Livingston from the LSE, there were key movers and actors in getting General Comment 25 adopted. And essentially what General Comment 25 does is put a modern spin, a modern interpretation, specifically addressing the digital environment in relation to that foundational document adopted in 1989, I think it was, the UNCRC itself. And all it does, in a way, is spell out in using more modern language, and so referring specifically to the online environment constantly, how governments and states should respond to that. But I want to just turn, I don't want to abuse my position as chair too violently. So I want to just turn to some things that are happening now, as it were, because it's not, in general, we've been doing well. I mean, I was amazed yesterday, I don't know if you were in the room, when that woman from Persona presented her digital map showing, and she said she's monitoring around the world what different legislative bodies and governments are doing to try and improve online child safety. And she's documented on her website 400, it is current, 400 different proposals or laws in 40 different countries around the world that have already been adopted, which specifically address some aspect or other of online child safety, designed, in other words, to honour, protect, advance children's rights in the online space. So around the world, there is definitely a much more progressive frame of mind towards online child protection, more than there's ever been before. In some of the, when I was working with the European NGO Alliance for Child Safety Online and ECPAT International, who I worked with for over 20 years, we did some surveys within the European Union. Sadly, as you know, we're no longer part of it, but never mind, we'll come back to that later. And we found the levels of support for improved, stronger, better online child protection measures in some countries was way above 80%. We're definitely moving with the tide of history. Public opinion has definitely caught on to the fact that whilst technology is and can be wonderful and extremely helpful in many, many ways to children, there are far too many risks associated with it which have not been properly addressed. These don't affect all children or every child, but they affect far too many children to be tolerable or acceptable. And there's very, very strong support amongst the public, therefore, for strengthening laws. And what we're seeing in the field of age verification is an example of how that is having a direct political impact. But it's not all good news, definitely not all good news, particularly within the European Union. Obviously, by the way, I hold an Irish passport, so I am an EU citizen. I will soon hold a Polish passport as well, so I'm kind of doubly invested in EU stuff. But I'm very, very glad at the moment that we're not part of the European Union, because there's been a complete disaster within Europe in relation to online child protection. In 2009, Microsoft, working with Professor Hani Farid, developed a piece of software called PhotoDNA. Some of you will have heard of it. This is essentially a technical tool which does hash matching, and it's used specifically, and it was designed specifically to allow online providers to identify already known images of child sexual abuse material and match them with a hash. You don't actually need the image itself, all you need is the hash, so that you could rapidly and at scale find any copies of that image and then delete them from the internet, report them to the authorities and the police, and get them dealt with. And bear in mind, by the way, I mean, in some studies I've seen, 90% of all of the child sexual abuse material circulating on the internet has previously been seen and classified as child sexual abuse material. So obviously PhotoDNA is extremely valuable as a way of identifying in milliseconds those images and getting them removed. Because if you talk to the victims about these images, the children who've been raped and abused and are depicted in these images, they are clear. Look at the Phoenix 11's website, look at the Phoenix 11 statements. These were all young girls at the time they were raped and abused, now young adult women who are willing to speak out. They are very clear. What they want is those images identified as quickly as possible and removed from further public view as quickly as possible. And that's exactly what PhotoDNA does. And since 2009, all kinds of companies have been using photodNA on a voluntary basis to do exactly that. And the numbers of images that subsequently get reported to the police, usually through NCMEC or one of the hotlines around the world, are in the, well, by now it's in the hundreds of millions, if not billions. It's worked on a gigantic scale. And there has not been a single case, not one case, that's been reported of this technical tool getting it wrong in a way that led to anybody being arrested, much less prosecuted or convicted. It has been a highly successful mechanism for protecting children's rights in the online space. Related to that, Google and Meta and other companies developed tools which they call classifiers. So these are tools which allow them to identify images. It's sort of AI-like, if you want, which have not yet been seen and classified and put into a database of existing child sexual abuse material. But because of all of the metadata and stuff, as it were, surrounding the image itself, the AI tool or the classifier knows that this is very likely to be child sexual abuse material. And so it can be taken out of the stream and looked at by a human. And if the human looks at the image and sees this thing and sees that it is actually child sexual abuse material, it's deleted and removed and treated as if it was child sexual abuse material. So that's another kind of, it's a byproduct of the original kind of master tool, which was called photodNA. Meta and Google and other companies, by the way, have provided free access to them. But again, lots of platforms have been using classifiers on a voluntary basis precisely to try and minimize the levels of child sexual abuse material that their service might be providing. And the third tool, which again is sort of, it all starts with photodNA, the third tool that's been very widely used identifies behavioral signals that suggest that a child who is online and live is being groomed for sexual purposes. And what that does, it allows an admin person on the platform to intervene and direct the child away or into a safer environment or provide support in some other way. Each of those three tools, all of which were highly welcomed obviously by child protection people around the world, all of which have been used beginning in 2009 on a voluntary basis, are now illegal within the European Union. Not in the United Kingdom. They continue to be used here. They continue to be used in Australia. The only place in the world where it is illegal to use these tools is the European Union. I'm happy to say, by the way, that Microsoft, Google, Snapchat, and a couple of other companies, I can't remember the full list, but there are some who've said publicly they intend to ignore the law. They intend to carry on using those tools, and we'll just have to wait. And their argument is that even though it's fairly clear what the law was intended to do, stop them being used, they're going to run the risk of being sued by somebody, and basically they're daring somebody to sue them to test the extent to which the law has been properly interpreted. And I think they may have a case, because the European Union is, after all, a signatory to the UN Convention on the Rights of the Child. It's a signatory to a whole range of legal instruments which pledge it and oblige it to protect children to the best of its ability. So there is, at least on the face of it, a conflict of laws between those sets of obligations to protect children and what they've done now, which is make it illegal for companies to use tools which have been shown to be highly effective in doing so. How did it come about? It came about, I'm afraid, there's my good friend from Germany, I'll be very careful what I say now. It came about because a junior judge who used to sit as a judge in Schleswig-Holstein, Patrick Breyer, who subsequently got elected to the European Parliament, came up with a very snappy, snazzy slogan, which was a complete lie, but a very effective lie. He said that what these tools effectively do is allow for chat control, because when they're used in connection with messaging systems, they technically provide the possibility that messages could be examined or scrutinized by the platforms themselves and by extension by police agencies or state bodies or so on. So he conjured up an image using that slogan, chat control, of these tools which were explicitly and exclusively designed for the protection of children being misused and abused without evidence. Let me repeat, there is no recorded case of anybody ever being arrested, much less convicted, or of any other bad things happening because of the use of these tools. But the fact was, 10 years earlier, they passed something called the e-privacy directive, which appeared on the face of it, at any rate, to make the use of any tools which can scrutinize messaging apps unlawful under the e-privacy directive. So they conjured up an argument. I'm sure at the time that e-privacy directive was adopted by the European Union, it was not anybody's intention. They hadn't foreseen the unintended consequence of the problems that have subsequently been caused by that law. But nevertheless, that's the position that we're in now. We will see. Something like this did happen before in 2021-22. Somebody raised an issue about the proper interpretation of the e-privacy law, and Meta, don't know if there's anybody from Meta in the room, but Meta, showing an abundance of caution, showing an uncharacteristic desire to make sure they were not breaking the law, immediately abandoned using the tools, temporarily at least. During the 7 months that Meta stopped using those tools because it was worried it might be breaking the law, uncharacteristically, as I've said, there was a 58% drop in the number of reports of illegal content that were being received on a global basis. 58% fewer cases of child sexual abuse material being identified, only because one company, admittedly the biggest player in the field in this context, had stopped using the tool. So we will never know how many children could have been rescued, could have been identified, could have been removed from an abusive situation and weren't, because of that 7-month gap that Meta chose to inflict on the world, if you like. Now now all platforms, at least in theory, could be at risk and could be required to stop using those same tools. So it's a very, very bad situation. It's going to have consequences globally because the abuse isn't going to stop. The children are still going to be getting raped. Images of them being raped are still going to be circulated, but it will overflow into other countries. So even though we're in the United Kingdom, we are not party to that. Nothing's changed here. The overspill and the effects of people who are not being caught, as it were, who would otherwise have been caught, leaving them free to continue to abuse, will impact on us. So now, one final point. You will have gathered earlier, it was around the issue of privacy that the objections were raised to to the continued use of these tools. And this is going to be a major area of conflict. Well, it already is, but it's going to be an increasingly important area of conflict because of the emergence of very strong encryption technologies. There's one in particular called ADP, which is incorporated into Apple's products. So if you store anything outside of the United Kingdom, at any rate, if you store anything outside of the United Kingdom in iCloud, what will happen is that your stuff, as it goes up and gets put into the cloud, will be encrypted using ADP technology, which is unbreakable. What that means is, even if a court or a police officer or whatever gave an order requiring evidence to be produced in a case, Apple couldn't do it even if they wanted to do it. And by the way, they don't want to do it, but even if they wanted to do it, they would not be able to do it. So in essence, what we have created, and by the way, these messaging apps and so on that use ADP, Signal and Telegram and so on, use similar sorts of tools. They are proven to be a key area of activity or key space in which paedophiles operate and exchange things. So this is not without consequences for child protection. But the point is an obvious one. these technologies are essentially challenging the rule of law. Because if the courts and if our legal systems cannot get access, as they historically have done over the centuries, can no longer actually get access to evidence necessary in a case, what does that say about our future? It's a sign to criminals everywhere, and keep on, just make sure if you're going online that you are using these tools, because if you do, there isn't a police force in the world, there isn't a court in the world that will be able to get the evidence that might ultimately convict you and send you to prison or worse. So I don't think in the long run, the liberal democracies will be able to live with this state of affairs, because it's a direct challenge to the idea of the rule of law. And I think it is, as it were, the next big battle that we're all going to have to face. It impacts on the age verification and age assurance industry around the edges in all kinds of ways, because what you're about is trying to protect children, and these tools are, as it were, a direct challenge to many parts of it. I've already actually gone over my limit. Well, not quite. I've got a few minutes left, so I'll stop now. And if there is a question or a comment, challenge, whatever, please feel free to make it. Question? I am a blogger, by the way. I blog on, and I've written something specifically about the US jurisprudence, those US Supreme Court cases, if anybody wants to see it. And I blog at Substack, so you can catch up with some of my stuff there. Okay, I think we're done. Thank you very much.